you can make it and come with us. Today, we have one of the opening sessions, one of the round tables, which is going to be presented in advance and will be repeated, probably with more or less same participants in Cartagena. This time is artificial intelligence and the world of law and the rule of law. This is a new frontier. This is a new challenge. This is a consequence of the digitalization of society, where artificial intelligence is offering the new challenge also for the rule of law. There are many contradictory points. There are many opportunities and many challenges as well. So a lot of discussion is going to be today. We're going to see how this opportunity could be taken in advantage for the dignity of human being, for promoting the rule of law, the only alternative to the rule of man, to the rule of force, to abuse of power. So we're going to see how this can affect to the practicing professions, judges, attorneys, prosecutors, also to bar associations and institutions in the world of the rule of law. And I want to first thank you very much, Mrs. Viviane Reding, our Vice President of the World Law Foundation, who has been chairing this opening session. She's going to present the speakers. I'm going to pass the floor to her. Before, I want to present you a videotape of President Duque. Before this videotape, I just want to remember three main ideas. The first idea is this association, World Jurist Association, was founded almost 60 years ago with one single purpose, which is to promote the idea to not just to legal professionals, but to every citizen, that the only alternative to war, the only way to get peace and freedom is to support the rule of law. At that time, the Iron Curtain was announcing the commencement of the Cold War. Today, the Cold War is over, but we have different versions of this Cold War. We have different threats. We have a lot of millions of people living under attack, under pressure, and the rule of law is the only hope for them. So one single purpose is to promote the rule of law. Second idea is we are going to celebrate in July 5th, on Monday, July 5th, we're going to celebrate the inauguration of the World Law Congress. The opening session will be taking place in Madrid. I hope you can make it. I hope you can be here physically. The Spanish King is going to be opening the session together with President Duque from Colombia. And we will have a unique opportunity to participate in a discussion that never took place up to now, which is a roundtable comprising presidents of the 6 most important international courts of the world: European Court of Human Rights, European Court, the European Court of Justice, hopefully also the International Court from The Hague, International Criminal Court, Inter-American Court of Human Rights, and African Court of Human Rights. They're going to have a discussion for the first time together. It's going to be in Madrid. It's going to be as the last opening session to the World Law Congress in Colombia. So please participate. Please join us either physically in Madrid or digitally. And we will also present the Ruth Bader Ginsburg medals to a number of women that has been showing leadership in promoting rule of law. That will again take place in the framework of the Madrid July 5th gathering. I hope you can make it. It will take place in the City Hall of Madrid, a brand new, with very spectacular facilities. And we will have place for you guys, leaders of the legal profession. And please join us. This is the second idea. The third idea is a little bit about in artificial intelligence. You know that judges are starting to use it in America as to predict whether someone could be committing again or is a threat for the community. But we can find many other many other uses and opportunities in the rule in the artificial intelligence for the rule of law. So I just wanted to recall that Justice Roberts, John Roberts, President, Chief Justice of the Supreme Court of the United States, visited in 2017 the Polytechnic Institute in Rensselaer, Troy, New York. And this is a very important center to promote artificial intelligence. And he presented a question. And this is what I want to end my intervention here. Can we foresee a day where intelligence, artificial intelligence, machines actually, driven by algorithms, will be helping tribunals to determine facts, including decisions? And his answer to this was that this day is already here. And it's putting a lot of pressure how judicial power, how judges are going to handle this. But this is not anymore the future. It is already the present. We just have to figure out how to gain this influence in favor of the rule of law, how not to denaturalize what is the rule of law, what is there for. This anthropocentric view of the rule of law is compatible with artificial intelligence? I think so, in a certain way, but we will hear now the experts. I will pass on the word to Mrs. Viviane Reding. After this videotape, Mrs. Viviane Reding is in use of the word, in use. She is sharing this session. So thank you, everybody. Thank you very much. It's a pleasure to meet you again, and hope to see you in Madrid, July 5th, and Cartagena de Indias, December 2nd, December 3rd. Thank you very much.
Thank you, President Duque. And we are all looking forward to a very fascinating Congress at the end of this year in your beautiful country. Our host country today is Luxembourg, one of the small countries in Europe. It is known to probably all of you for its important financial sector, home to many European institutions, among others, the European Court of Justice and the European Prosecutor's Office. Less known, probably to all of you, is that it is also the specialized steel from Luxembourg, which is built in your skyscrapers, in your ports worldwide. And that Luxembourg is the first ever commercial satellite company hosting and having it still today. And on its territory, and there I come now to the subject, we have an astonishing number of big and of startup technology companies, supported by lively research centers. And it is so not by chance that the Prime Minister of Luxembourg is not only Prime Minister, but he is also Minister for Media, Communications, and for Digitalisation, because we want to develop this country in order to become a digital hub in the world. Your Excellency, Xavier Bettel, Prime Minister of Luxembourg, the floor is yours.
Thank you very much, Viviane. And my dear Javier, could you please switch off your microphone because we can hear everything you are doing. For the moment, it's not embarrassing, but we don't know. So, firstly, Viviane, I would like to thank you because without you, I wouldn't be here. I have to tell you that Viviane is very active in that topic in our parliament, but she was also on European level in charge as Vice President of the Commission of all the digital agenda. And so even if she is in the opposition in our parliament, she's a big help to promote also the digital agenda in Luxembourg politics. So I really would like to take this opportunity, Viviane, to thank you for all the work you are helping in this topic. I'm very pleased to be guest here and to have a short statement on that. Maybe some of you have never been to Luxembourg, so be welcome to this country with about 650,000 inhabitants. Nearly over 60% of the population in the city are non-Luxembourgers, and we know then being different is a strength and a melting pot of culture and also of knowledge. I'm very happy to be here for different reasons. The first reason, as you said, I'm the Minister of the Digital Agenda, being also Prime Minister, but I'm also a former lawyer. And so I worked a lot on court. I was a barrister, so I did a lot of criminal law, and allow me to have a political statement, but also a practical statement as a former criminal lawyer on that topic. The first thing is AI is developing very quickly for the moment. We see that it is developing, it's taking part of everyday's life, and it has a direct impact on our societies already yesterday, today, and even more tomorrow. The biggest challenge is also to get the trust from our people, from our citizens, that they are scared about AI. For the moment, for a lot of people, AI means for a lot of people, AI means that some jobs will disappear, that everything will be replaced tomorrow, that they might lose their job. Even for lawyers, there are some people who think that with AI you won't need to have lawyers anymore. I do not believe, because we have just to remember that we as human, we are the one who design and also to develop, and so we choose the extent to which this technology will benefit also our societies. I push in my administration the AI in favor of hands-on experimentation. So it's not only about programming, and we shouldn't be blinded by shiny technology. Javier, por favor.
No importa, no importa, no te van a ir. Venga, ponte otro pantalón, corre. Venga.
So what is important is that we have also transparency, and we have to ensure also human dignity and human rights are also respected. It's difficult asking that from a machine. So we finance projects in Earth observation, outlier detection, natural language processing, object detection, and the whole range. And we have training sessions also with our civil servants on the opportunities and the risk also of AI. It will, for me, with the decision of AI, if AI will take decisions, you always have the right as citizens to get a human control. There should be always a possibility that not a machine is just going to decide what is right or what is not right. And on the other hand, what for me is very important, that you have then a human. Human is not just there to push what is on the screen to say yes or no because the machine decided that it should be yes or no. We need rules. We have in Europe the GDPR to protect personal data, because this is also the backbone of everything. And it should have strict control criteria to prevent also decisions taken for a whole bunch of persons just because they are in that situation, because criteria and the sensitivity should be something which is very clear. So on political level, we should push. To be very frank on AI, we have as European continent to be more active also, because we know that a lot comes from Asia, a lot comes from the United States, and we need common strategies on the AI in the European Union. We work on that, and because I don't want to be squeezed afterwards as a continent and be dependent on two other bigger continents. So we need to be more proactive on that topic, but by taking the people with us. If the people don't, it's like the 5G, sorry to make a link, but if people don't know what will be the technology, what will change the technology, what are the capacities of the technology, they will be scared. And then it will be a big mistake if they do not understand the advantage. But if we can explain true health, that we can have diagnostic, that it brings them easier in life, everyday's decision easier. So that will be something very positive, and we have to explain it also through that. So now, law and artificial intelligence, by having all this backbone, which I think is very important, we in Luxembourg, the first thing was the justice was given in the name of the population. We should not forget, it was in the name of people that we gave to justice. So we had also in a lot of countries what we called the popular jury, where the people decided if you were guilty, and if you were guilty also with the judge, what would be the sentence in a range. In our country, we decided to take away the popular jury. So it's a professional judge who is making decisions for criminal cases, or for all the criminal law cases. It's professional judges, so not anymore. So on that way, the first, as a criminal lawyer, the jury was already trying to convince the juror, to convince the jury about the difficult use, about the specificity of the case, about the circumstances. With judges, it was already harder, because you have circumstances which are in the books. You cannot say this is something which is guilty or not guilty, because you've got a feeling, because the judge, it's right or it's wrong, or it's the personal opinion of 3 judges or 5 judges if it's criminal. And then at the end, if you have a machine who should decide if you are guilty or not with the information you give them, is it still in the name of the population? Is it still in the name of people that you give? Because there will be no arguments. The machine will be boom and give you a decision, and not being able to discuss. I love to go to court. I love to explain to judges why. I don't want to stand in front of a screen and trying to explain why, or trying to convince the machine why this was maybe not that clear, or not that guilty, but not as bad as it seems if you just read the police document. So as a lawyer, I have to tell you that it will be hard for me, because I don't want to say feelings, but impressions, and also to understand that the people will learn something from their fine, or they learn something from their sentence, is something which is important for me also to have the psychological aspect of a sentence. So it will be very hard to tell you what is the best. For me, it is complementary. the artificial intelligence should really help us also as a lawyer to be able to fight everything, also to make it easier for people to get access to justice, it's not the judge, but it could be when I write something in, to have an impression what could be a decision, but not the final decision. So I think this might be, you said, Javier, that this would be already a possibility today. I believe that justice in the name of people should still be done also by people. Sorry, Viviane, I was a bit long, but as you can guess, being a politician and a lawyer, when you give me the floor, it's always difficult to stop. So thank you very much, and I wish to all of you a very nice meeting.
Thank you very much, Prime Minister.
Muchas gracias, Primer Ministro.
Very important to have your
muy importante
opinion on this.
Contar con su
On
punto
this
de
new
vista
frontier, on this new challenge,
sobre este
under
nuevo
the ethnic
desafío.
control of the humans, and that brings
En
me
el que
to
las máquinas van a tener el
personal,
control de las personas.
opinion also.
Y con esto también quiero
I think that the
compartir mi opinión
artificial
personal.
intelligence is neither artificial
Yo
nor
pienso
intelligent.
que la inteligencia artificial ni es artificial, es
A
simplemente
tool,
una
a
herramienta.
man-made tool, in
Una
order
herramienta
to
que ha hecho el
sort
hombre
out the great number of data
para
useful
clasificar
to
el gran
find
volumen
the
de
facts
datos,
more easily, more
lo que
swiftly,
dice
but not
es más
to
fácil para
replace
averiguar
you.
los datos de una
It's
manera
only
más
to
útil,
help
más
humans
práctica,
to
no
be
para
more
reemplazarlos,
efficient.
sino para
And in order
ayudar
to
a
benefit
los
from
humanos a
this
ser más
tool,
efectivos. Si
and in
sabemos
order
cómo
to
beneficiarnos
control its
de
functioning,
esta
avoiding the
herramienta
biases, avoiding the
para hacer un
partiality,
control que no tiene sesgos,
you
que
have
no
to
tiene
know the system.
parcialidad, pero tenemos que
And
conocer el
only if you know
sistema.
the system
Y solo si
can
conocemos
you
el sistema,
dominate it. So our discussion today is a wake-up call. It's a wake-up call for lawyers, for judges, for specialists. Get to know the functioning in order to avoid the pitfalls. And who better than world-renowned specialists can introduce us to this matter? We have with us Marina Teller, Professor of Law at the Université. She is the head of the Scientific Chair Law and Artificial Intelligence, and she's going to keep the discussion in her hand and start with the challenges for justice in the new technological ecosystem. She is going to be joined by Karim Benyekhlef, who is a professor at the Université de Montreal in Canada, director of the Cyber Justice Lab, and he's going to speak about artificial intelligence challenges for courts and judges. And then the third one is Gregory Lewkowicz, professor at the Université Libre de Bruxelles and program director at the Perelman Center. He will speak about the artificial intelligence challenges for lawyers and bar associations. So to all of us, I wish a very fruitful discussion, and I hand over to Marina.
Many thanks, Viviane. I'm going to share my screen. Yes, okay. So, hello everybody. I'm very pleased to participate in this conference, and I sincerely thank the organizers of this event, and more particularly the designers of this program, Mr. Cremades and Mrs. Redding, President and Vice President of the Lord Law Foundation. I'm very honored to share this floor with the President of Colombia and the Prime Minister of Luxembourg. And finally, I'm also very proud to talk with two great experts in AI and law. They are not only experts recognized on a global and European scale, they are also my colleagues, and it's a real privilege to share an intellectual moment with friends and to offer it to all. So, my topic is challenges for justice in the new technological ecosystem. And it will be a kind of introduction for our two guest speakers later. We all know that justice is rooted in the history of mankind. Justice has been built over time with human societies. It has evolved with them and has always been able to adapt to social transformation. Today, we ask ourselves what are the challenges for justice in the new technological ecosystem? Are deep technologies changing the idea of justice? Do they transform justice? What is new for us as lawyers in the era of the new technological and mathematical turn? To get started, let's maybe first define what these new technologies are. They are said to be disruptive. They are internet networks, blockchain, big data, artificial intelligence, of course, but also quantum computing, deep learning, and neural networks. These deep technologies are leading to a paradigm shift that deeply affects our society. And we see this every day. Most of the institutions created for decades are disturbed or called into question. And this is particularly true of the concept of currency, of the concept of sovereignty, but also of democratic accountability, truth, and maybe even freewheeling. But this is also the case for the freedom of expression in the face of digital platform and even of the international governance in the face of the most powerful commercial companies in the world. Some fear that digital technology has become a real political force, a kind of algocracy, but without the checks and balances that exist in the democratic tradition of states. Big data realizes a new mapping of knowledge thanks to data, which is the new oil of our hyper-connected and hyper-technological societies. Economic, but perhaps also political power has shifted to big companies that know how to collect and how to process this data. The risk is perhaps to give birth to this technological solutionism or this surveillance capitalism that academics denounced. We can highlight the main trends of this new technological ecosystem. AI is a game-changing which reorders the cards of power. It is both a new challenge and a new obstacle to overcome. Some feel that deep technologies will transform the conceptual framework of the rule of law. And indeed, there is a very strong common point between computer language and legal language, because both have a normative function and a normative force, and both are code. And we know from Laurence Lessig that code is law. And the question is whether AI will modify the law to the point of giving rise to a computational law, the reasoning of which is no longer focused on causality, but on statistical power and correlation. Law is based on the rule of reason, while computational law is based on another logic, that of the law of large numbers and probabilities. This regulation by numbers is a hallmark of algocracy. This concept of algocracy is a mode of governance where authority is more and more embedded in technology itself, or more specifically, in the underlying code. As Marshall McLuhan said, we shape our tools and then our tools shape us. And we have built algorithmic governance systems that end up transforming us in their image. The risk is that the law becomes simply a metrics business. And the question we ask ourselves is, what will be the end result? Is it to digitize democracy, or is it to democratize the digital? And finally, we fear not only a coup d'etat, but maybe also a coup d'etat. So there are a lot of fears and stress, and we know that. But we believe that there is also a fantastic opportunity to think differently about law and to reinvent the future of the rule of law. Deep technologies should encourage us to create new fundamental rights, what I would call a deep law, to deal with all these challenges. We are building it by designing rights that are embedded into technological devices. Justice, fairness, and loyalty must become standards in algorithmic processing. The scope is to promote the idea of ethics and maybe law by design, and also accountability of algorithm. The issue at stake is essential. Human rights are today, and will be more and more tomorrow, a matter of technology. We need to bring low and deep technologies together to avoid a machine capture of political decision-making. The art of choice and decision-making must remain within the scope of human actions. And we urgently need a legal framework in the field of AI, not only to set the rules for AI, but also to establish the rights of people in the digital age. I think we face today new problems. For example, neuroscience and neurotechnology open unprecedented possibilities for accessing, collecting, sharing, and manipulating information from the human brain. And some academics, Lenka and Andorno, have proposed to establish new fundamental rights in the context of neuroscience to protect the integrity of mind. Europe is also a very interesting source of inspiration. We know it is a laboratory of legal innovation with a diversity of legal tradition. The Culture and Education Committee adopted a resolution a few days ago so that the values of the European Union can be reflected in the online world, where algorithm and AI application are everywhere. Indeed, the use of AI technologies in education and culture could have an impact on the backbone of fundamental rights and values of our society, said that committee. And as a professor of law, I find it remarkable that this committee has underlined the importance of knowledge and education. And this is probably the first step on the path to regulating AI. The transmission of knowledge is an essential stake in an algorithmic society where the big data is widespread. And it is no longer a question of giving information, because information now is open and free access most of the time. It is about developing what we call the 4 C's. That is to say, critical thinking, communication, collaboration, and creativity. Deep technologies challenge lawyers and cyber justice. So here is a great call for actions to lawyers, and I'm very proud to give the floor to my 2 colleagues. We worked all together in the Deep Law for Technology programs in France. This is Karim Benyekhlef from Montreal. He is the director of the Cyber Justice Laboratory, which he founded 10 years ago, and is probably one of the best experts in the world to understand the implications and possibilities of deep tech to transform justice into better justice. And then we will happily listen to Professor Gregory Lewkowicz from Brussels. He's a chairman of the European incubator of the Brussels Bar. As an academic, he did a landmark study on the smart law, and his research focuses mainly on the transformation of law and also legal professions in the context of the digital turn. To conclude, I wish that AI was an opportunity to build common values on a European and global scale in order to contribute to a new universalism of human values. So let's start with you, dear Karim, about the challenges for courts and judges of AI. I stop the sharing and I leave you the floor.
Thank you. Thank you. I'm going to share my screen. So if you see the...
Yes, it's okay.
Yes, okay. So I'm going to put it on écran. Okay. So good morning and good afternoon. It's a pleasure to be with you today on such an important subject. Well, as AI ecosystem is penetrating every aspect of our life, to what extent should we allow AI-driven automation within our code system? As we tend too often to forget, computing is also a political choice. The proven efficiency of computing AI analytics in certain areas does not prejudge its adequacy on other issues less amenable to computing or quantitative analysis. We should also bear in mind that under the cloak of objectivity and unquestionable scientificity, artificial intelligence is, at the end of the day, the fruit of human engineering, carrying the risk of magnifying or at least perpetuating human errors and social biases. To speak about AI challenges for court and judges require first a broad overview on the various ways in which algorithms may interact with our judicial systems. Generally speaking, we may classify the possible judicial uses of algorithm as follows. Algorithm as constitute or providing what may be called machine learning evidence. Algorithm as support for decision, which came to be known as legal analytics. And judicial analytics, i.e. the systematic analysis of judgment handed down by individual judicial officers. Machine learning evidence refers to the critical retrieval and analysis of judicial evidence, such as data mining applied to emails, mobile phones, and social networks. It is commonly used in relation to e-crime investigation, be it credit card crimes, copyright breaches, possessing or distributing objectionable materials. In the common law jurisdiction, the process of e-discovery may also harness algorithms to help sort out large documentary evidence and appreciate the relevance of documents to a particular civil case. Legal analytics, or AI analytics, as applied to legal data, provides support for judicial decision in multiple ways. We may understand legal data in a narrow sense as being restricted solely to case law, court dockets, statements of fact, and pleadings. Legal data may also be constructed in a broader sense as including the processing and analysis of relevant data to the case at bar, such as the use of algorithmic tools to assess and accuse the risk of recidivism in pretrial custody, bail, decision-making, or even sentencing. Within the European Union and Canada, decision makers have been careful not to accept too rapidly the use of AI tools for decision support purposes. Most of the initiatives come from the private sector and are not often integrated in public policies. In the US, since the mid-90s, predictive algorithms have been used in law enforcement and criminal court for risk assessment purposes. Judicial analytics, on the other hand, come one step ahead with the purpose of investigating individual behaviors and tendency of judges and other decision makers. Proponents claim that AI opens up a new frontier in judicial governance and accountability. Responsible use of AI indeed holds great promises on several fronts. It helps improve either the quality of evidence, the efficiency of justice, objectivity in decision-making processes by replacing gut feelings and arbitrary discretion by quantitative standards and data-informed decision, as well as legal stability and predictability. Legal analytics may elicit a fine-grained pattern of the case law history and trends that will prove very helpful to litigants, legal scholars, professionals, and judges at the same time. As acknowledged by the Ontario Superior Court of Justice on one occasion, computer-assisted legal research is of course here to stay. Judicial analytics in particular may provide additional insight on the work of judges and the court decision-making process, from which may be expected an increased transparency and knowledge about courts to the public, which is good, as well as an increased awareness of human fallibility and social sources of bias in the decision-making process. That said, the use of AI tools in the judicial context raises some key challenges. Firstly, how to preserve judicial independence from AI processing has become an increasingly critical issue. As in other areas of life, AI is no longer a simple facilitating tool, but it's becoming an ecosystem by itself. In the judicial context, legal analytics and machine learning evidence have come to interfere with the court process in increasingly intricate ways, ranging from e-filing to case management. The current pandemic crisis further highlights and enhances the role of technologies in our court process. One may argue that the advent of expert evidence, be it AI or otherwise, to assist judges in deciding complicated technical issues or data is not new and should be welcomed to the extent that the proposed expertise contribute to a better understanding of complex issues. But what about AI jurisprudence though? How far should legal analytics be let go in predicting settlement, arrangement, judicial decision, and other outcomes of claims? How to prevent unconscious over-reliance on algorithm and machine learning engineers? How to prevent algorithm manipulation of data? These questions are worth asking, as reliance on algorithmic case law processing may result in securing an AI monopoly over the core of court expertise, i.e., analyzing relevant case law and approaching similar factual scenarios in the same way. From such AI control over case law processing come concern, of course, over securing due process in the automated age. Procedural due process calls not only for substantive justice to be done, but also procedural fairness in the course of the administration of justice. Procedural fairness as the requirement for fair and proper procedures includes the right to an unbiased tribunal, the right to take notice of the opposing evidence, including the right to cross-examine adverse witnesses, the right to present evidence, the right to counsel, and of course, the right to a reasoned decision. On the other hand, substantive due process protects the litigant's fundamental rights from the unlawful interference of government officials, including the right to equality and freedom from discrimination, the right to reasonable expectation of privacy, the right to reputation. We should also be increasingly mindful of the subtle control of law enforcement processes and interference with fundamental rights by the private tech sector, such as controversial face recognition systems that feed and improve on images gleaned from the public web. And of course, I'm referring here to the Clearview AI example. Indeed, fieldwork studies on the reception of predictive algorithm in the US criminal courts have pointed out that technologies tend to replace, not to replace, but rather displace discretion to less visible and therefore less accountable actors, including data analysts, data entry specialists, and technology teams who create novel forms of discretionary power within the institution. In the automated age, the world and the law as we know it bear the risk of being swept away by the seeming omniscience of algorithmic computing, which promises more efficiency and less arguing under the mystique of technology. In a way, it is relieving to know that at least some US criminal judges and law enforcement officers, as empirical data have shown, are much careful when it comes to replace human discretion by mechanical or computational procedures. We must bear in mind that our all contemporary judicial process is no longer centered on the mystique of authority, be it trial by ordeal, technological or otherwise, but on ensuring a fair process, allowing contradictory debates over opposing evidence, nuanced case law, and divergent legal interpretation. How to ensure human oversight on the design, development, and use of algorithm, especially in the judicial process, has bring about many thoughts on algorithmic transparency, AI literacy among judges, counsel, and litigants, and safeguards on algorithmic coded bias and resulting systemic discrimination. From this concern stem emerging best practices as collected by multiple actors, the European Commission, the Council of Europe, Canada, Commission in Canada, and in the US. The European Commission for the Efficiency of Justice, CEPEJ, from the Council of Europe, adopted in December 2018 an European Ethical Charter on the use of artificial intelligence in judicial system. The Charter lists the 5 following principles of the ethical use of artificial intelligence in courtroom setting. First, the principle of respect for fundamental rights. 2, the principle of non-discrimination. 3, the principle of quality and security. 4, the principle of transparency, impartiality, and fairness. And lastly, the principle under user control. The Charter also establishes as well the distinction between uses of AI that should be promoted in judicial setting, possible uses that would require considerable methodological precaution, uses to be considered following additional scientific studies, and uses to be considered with the utmost extreme reservation. Those distinctions are based on a spectrum of increasing AI control or decreasing human control over judicial process. That being said, ethics is not enough. To address the challenges raised by algorithmic justice would require a more prescriptive approach, which is what the Law Commission of Ontario, for example, proposed as a smart mix or mixed model of AI and algorithmic regulation. The Law Commission of Ontario proposition specifically target the criminal justice system. Considering that no one single statute, rule, or practice is likely to be sufficient to governing AI and algorithmic systems, the Law Commission of Ontario suggests a comprehensive regime to ensure algorithmic accountability in the Canadian criminal justice system, which should include the following elements in light of the principle of technological due process that I referred to earlier. Algorithmic transparency, meaning by that access to the code and to the data by a public authority. No secret des affaires in that. Bias, non-bias and equity. Public participation and data literacy, as well as due process, evidence, remedies, and the right to counsel. In the US as well, attempts to build a research agenda to protect individuals' constitutional rights in light of advance in technology have been most prominent in the criminal justice system. Last but not least, the Cyber Justice Lab is currently leading the Autonomy Through Cyber Justice project composed of 56 researchers and 42 partners. This is a unique research partnership that aims taking advantage of AI to the service of justice stakeholders and at tackling key challenge on the way to cyber justice. The ACT project includes 3 working groups and 16 distinct research sub-projects, bringing together a multidisciplinary and international team of experts, academics, judges, litigants, legal professionals, as well as main users and developers of AI for justice in Canada and the US. Spanning a period of 6 years, the final stage of the ACT project is dedicated to developing best practices tailored to the actual need of litigants and a governance framework capable of ensuring fair use of AI in the justice system. To conclude, I've said at the outset of this presentation that computability is a choice in itself. In harnessing AI potential to help facilitate and enhance our judicial processes, we must bear in mind what may or should be computed versus open concept issues or aspects that cannot be wholly grasped or adequately resolved by mathematical tools or automation. For instance, it may be much more difficult to computerize the reasonable person standard in determining civil liability for personal injury cases. Neither do the scope and extent of our constitutional rights, such as freedom of speech or protection of privacy, for example, lend themselves to a precise mathematical formula. By contrast, it will be much easier and time-saving to computerize the appropriate alimony amount for child or spousal support in diverse cases, as well as insurance claims and benefit, and also for what I call low-intensity dispute, like consumer dispute. There can be a very interesting avenue for AI there. Only by acknowledging the potential and limits of technology can we retain control in our human-driven society. Thank you very much for your attention.
So thank you, dear Karim, for these highlights. And Gregory, the floor is yours now.
Thank you very much, Marina. Thank you for the thank you to the organizer for this occasion to share about AI and the rule of law. So what I want to share with you is some ideas regarding lawyers and bar association and challenges that these two important actors are facing today with the development of artificial intelligence. And of course, we will be able to discuss later a little bit more about these the different challenges that I identify. Do you see my screen? Perfect. Okay. So Karim goes through the different issues for judges and so for the judicial system. I would like to address today a little bit more the challenges faced by lawyers and bar association. And I think it's really important to underline that lawyers and bar association have a very important role in not only guaranteeing the rule of law, but also producing the rule of law. Because it's they play a very important role in the cost, creative, and analytical work of interpreting, applying, adapting, and designing legal rules. And they are really a very important part of the law factory, because law is not only a set of rules, it's a set of practices. In these practices, lawyers and bar association play a very important role, and they are also very important in defending the rule of law. They defend the rule of law, first of all, probably because the defense of the rule of law is in the DNA of legal professionals, especially lawyers. But let's not be completely naive. It's also because you have some kind of, let's say, institutional incentives that lawyers are, attorneys are involved in the defense of the rule of law. To go back to Adam Smith, it's not from the benevolence of the butcher, the brewer, or the baker that we expect our dinner, but from the regard to the self-own interest. And so from that perspective, of course, you have institutional incentives for law firms, lawyers, and bar association to defend the rule of law, because it's a source, they want to protect sources of fees, social status, and controlling market for the services. And I do not see that as a bad thing, but more as a good thing, because they have a very clear interest in promoting the rule of law. But well, with let's say more generally the development of a digital society and of the use of AI, we are lawyers and practicing lawyers, attorneys, are facing a lot of potential problems. One of the most important one, and the one that they are facing right now, is first a problem regarding the trust that their clients may have. You know that the attorney-client privilege is something very important for lawyers, very important for attorneys, and because of because we are using digital technologies most of the time to do everything. You have a lot of challenges regarding cracking, hacking the information protected by attorney-client privileges. And it's not just an idea. It's really concrete. For several years, we have cases and more cases in which law firms were hacked by governments or were hacked by businesses. And this is a very clear problem today. And from that point of view, of course, cryptography and to develop some kind of strategy in order to protect and to keep the trust of the clients is one of the most important challenge today. But of course, this is not all the challenges faced by attorneys and bar association. We have, and I think that Karim went already into this point, we have, with the development of AI, especially when AI is used by government, but not only, we have several issues regarding equality of arms and adversarial process. And of course, these are values central to the rule of law, and that's central also to the role lawyers and attorneys have to play. So especially when in criminal matters, when you have some kind of automated processing of criminal evidence, it's really difficult for a lot of lawyers to challenge it, to challenge the evidence, because they do not have access to the different process through which these evidence were processed. And this is a very important issue today in different cases. And I think this is a very important challenge, for lawyers, for attorneys, especially criminal lawyers. But more generally, the problem, and Marina was introducing this, the problem is for lawyers and for attorneys to stay relevant to clients, because they need to be able to, of course, deliver what clients need, and at the same time to be able to address the kind of legal problem they have. So from this point of view, I just want to go through some example. You have today more and more companies, or more and more businesses that try to use AI in order to hire people. And of course, at some point, clients want to have an advice from their lawyer regarding, okay, can I use this system or not? Is this system discriminatory or not? And the law firm has to be able to answer this question. And today, it's not necessarily the case. And of course, this kind of advice that are really important in order to protect the rule of law, including human rights law in day-to-day business, is something that must be addressed. That is from the perspective of the business, but from the perspective of lay people, they also need to be able to rely on law firms that can address algorithmic issues and use of automated system in order to challenge this system in front of the court. Some of you have probably seen that several weeks ago, a court in Bologna decided that a system used to distribute work to delivery drivers were judged discriminatory. The algorithm was judged discriminatory by the Bologna court. In order to bring this kind of case, or other kind of case like the Syria case in the Netherlands, where the Dutch government was using some kind of system in order to spy on the poor, in order to address these kind of problems, in order to challenge these kind of techniques, you need to be able to understand, not to be, of course, you do not need to be a data scientist, but you need to be able to assess and to address and to understand how this kind of system work. And today it's not always the case. And of course, if in a digital society, if lawyers, attorneys are not able to understand what's going out there, then we will have a very huge problem, because as you know, law is the practice of law is not necessarily mainly about rules, but it's more about fact. So when you have a lawyer addressing a problem, an attorney, of course, at the faculty of law, we say it's all about the rules, but for the practitioner, it's more about the fact. It's all about the fact, providing fact, asking the good question, etc. And this require, I think, a little bit more knowledge about AI and informatics. And the reason why it's important that lawyers, attorneys take a move in that direction and start to really understand and to have some clue about how informatics is working, is that today they are facing a different program, a different competitors that pretend that they will bring and they will guarantee the value of human rights. It's the AI ethics movement, and you have really a lot of this movement everywhere. Not necessarily developed by lawyers, and you have, let's say, the technical standards only approach to AI issues. And of course, this technical standard only approach is an approach by engineer and not an approach by lawyers. And they have different way to look at the society and to understand values, and especially the rule of law. And you can see very clearly, and this is an extract from a book recently published about the ethical algorithm. You can see that the idea is really that some engineers or data scientists have the idea that they can replace what was the traditional rule of lawyers by a new science, what they call the emerging science of designing social constraint directly into the algorithm, and to internalize precise definition of things such as fairness and privacy. And you can see that with this idea that we will automatically implement fairness and privacy, that is something that lawyers would consider, especially when you have a clue about argumentation, that you cannot have a precise definition of something like fairness, because the idea of a concept like fairness is to be able to address a case and to address this specific case with a standard and not with a rule developed by a computer scientist. So there is a challenge there. And in fact, lawyers are already, and attorneys are already under pressure from the market to address the different issues raised by artificial intelligence. This is a paper published in the Wall Street Journal in 2019, and at least for big law firms, you have more and more big law firms trying to hire computer scientists and people doing AI in order to be able to address problem of the problems of today. So what is the role of the Bar Association in this context, and especially what the Bar Association can do in order to help lawyers, attorneys to defend the rule of law? You know that the independence of the Bar Association is recognized by the Commission de Venise, the Venice Commission, as one of the elements of important element of the rule of law. And I think that what at least the Bar Association can do is to include, and that was already done in the US, is to include in the duty of competence a lawyer's duty of technological competence. We cannot continue, and I know it was like this for years and years, we cannot continue in a system in which lawyers are people coming from good families but are not good in math. We need to have lawyers that are able to address statistical issues, statistical questions. They do not need to be statisticians, but they need to understand what it is exactly and to do some kind of calculation. And I think this is really important in order for lawyers and bar associations not to be put on the side of the important conversations that are going on today. And I would like to finish or to conclude my talk with this question of the different conversations. I take this approach from a book of Roger Brunswick, Law 3.0, and he explains quite, I think, clearly that we have at least 3 different conversations regarding law. The first one, that is the one that all the lawyers are acquainted with, is how to apply legal rules to a particular set of facts. That is the very classical questions, the very classical question of lawyers. And of course, the people participating to this discussion are attorneys and judges, because the courtroom is the venue for the decision. But then, since a lot of time we have another conversation, which is the conversation Law 2.0. And this discussion is this conversation is a little bit different, because the question is not how to apply legal rules to a particular set of facts. The question is, does existing rules are fit for regulatory purposes? And I think that we have a lot of discussion like this regarding AI, do we have enough rules? Are rules correctly designed in order to reach the purposes? And of course, in this discussion, you have lawyers, you have lawmakers, you have policymakers, and then regulators, but it's not completely clear for a lot of attorneys or bar association that they need to take part of this discussion. And then you have an additional question, and that is exactly a conversation, sorry. You have an additional conversation, and this conversation is the conversation that is going on today. It's not only a question about fitness for purposes, it's whether rules or technological measures are better fit for regulatory purposes. And this question includes lawyers, ideally, lawmakers, policymakers, regulators, and technologists. And you really need to have all these people together in order to address the question of this Law 3.0 conversation, rules or technological measures in order to fit your purposes. And this, I think, of course, this looks like purely some kind of jurisprudence or philosophy of law. But concretely, if you look what is going on today at the level of the OECD, with the approach rules as code and the idea that we need to create, in some area of the law, we need to create a kind of digital twin of regulation, with this idea that we need to have some kind of machine consumable version of some type of government rules. I think that we are really in this discussion about, okay, what should we use, law or some other kind of fix in order to address contemporary problem? And in this debate, that is, I have to say, I have the impression at least, that is led by computer scientists today, the position of lawyers, attorneys, and bar association are not necessarily taken into account. So in order to address the challenges of what I call smart law, that is a law, a kind of model of law that is more scientific, that means evidence-based, mathematical, because of course all the AI system are based on some kind of mathematical models, algorithmic risk and driven by risk and technologies. Lawyers have really a very important challenge to deal with this transformation of classical law into smart law. And if they do not address that, how to defend the values of the rule of law in the context of a digital society, then what we will have is something else than the rule of law, is some kind of technocracy driven by engineers. And engineers have not exactly the same kind of sensitivity to human rights. They are working differently. They were global standard setters for a long time, but so far they were not in charge of the defense of human rights. And I have to say, I'm a little bit afraid that this can come true. So especially if as a result of this kind of change in regulation, we are entering a very different world than the world in which most of the lawyers have studied so far. That is a world in which we use regulation in order to achieve specific goals that are set in metrics. We have seen that with COVID-19, we can reorganize most of the legal system in order to reach a specific goal that is flattening the curve. After the COVID-19, we will have a discussion about public debt and how to achieve sustainability, financial sustainability. And I'm quite convinced that some of the experiment that we have experienced during the COVID-19 crisis will be used in order to deal with public debt. And after that, we will have net zero CO2 emissions issue with also metrics and data-driven system, ideally. So that means that the most of the important challenges that we will face will be presented differently than in the past. And that in order to protect the rule of law in this context, I think that really lawyers and bar association have to start to have a reflection and a practice in order to incorporate the value of the rule of law in smart law. And I think the good time to start is now. Thank you very much.
Many thanks, Gregory. We have to be quick now because you are short on time. So I think after your two presentations, that cyber justice is probably a different matter from using algorithm in our daily devices. And both of you have tackled conflicting and difficult issues. We have understood we have to open our knowledge. And maybe just to start the discussion, I would like to ask to Karim at first. According to him, Karim, what are the main challenges for the future of cyber justice? What will be the future for this special kind of justice, according to you?
Thank you, Marina. Well, I think that before even thinking about implementing AI tools within the judiciary, we have a huge task before us, which is very simple. It's the computerization of the judiciary and the networking of judicial actors being the prime task at hand. We have to do that first before even thinking about implementing AI tools within the judicial system. You know, judicial systems are still in many countries based on paper. So before going to AI, let's move towards digitalization at first. I think that will be the main task at hand. That being said, of course, those AI tools could be used by judges or lawyers individually for legal research, as we've been doing for the last 30 years almost. Of course, the tools today are better suited to the needs of the lawyers and judges. So I think that at first we have to think about networking the judicial actors, meaning by that they must be in communication with each other to facilitate the circulation of information.
Yes, thank you, Karim. And maybe just to go further with the presentation of Gregory. I remember when you came in Nice 3 years ago. We met many practitioners, many lawyers, even judges, and sometimes when we talk to them about algorithm and the possibilities of using algorithm in justice, their reaction was sometimes very surprising. And we know that the question of the use of algorithm in justice could be not very easy for lawyers. As you work with the Bars Association, Gregory, could you share with us your analysis of the reaction of the various bars in the context of all these new technological tools? How do they react? What is the feeling? You are mute, Gregory.
Yes, thank you, Marina. I think it's quite different depending on what kind of attorneys you are talking with. I think that today big law firms are investing quite a lot of money to be able to deal with AI cases, and they are experiencing different kind of techniques in order to answer to answer to the need of their clients, because they have a very strong competition with the Big Four that have already invested quite a lot of money in using AI, for instance, in tax, etc., etc. So for these people, the question is how to do better with AI, and how to bring some kind of innovation in the deliverance of legal services. That is for big law firms. Then the question is a little bit different for small lawyers or people practicing alone. For them, the issue of AI, etc., it's more like it's a fear, because they do not feel that they can, if there is a competition regarding that, they do not feel they will be able to participate to this competition, because it's not a profession where people invest a lot of money in the business. The business is mainly their own competence, is human capital, and not some investment in in technology and so on and so forth. And a lot of them do not have a perspective on 5-10 years. So what they know is that they have a client and tomorrow they have to deal with this and this and that. But what will be the profession in 5 years, what it will be in 10 years, they don't have necessarily idea. And that is where the bar associations are doing a thing. And I think they are doing great. Could be faster, but of course you need to take into account the very big amount of people that are concerned. In Belgium it's 20,000, and we are a very small country. But in other country you have hundreds of thousands of lawyers, and in order to bring the discussion and to evolve, let's say, all together, that takes a lot of time.
Thank you, Gregory. And I check the time. I think we have still 5 minutes maybe to answer question from the public.
That's right, Marina, and thank you to the three speakers. I have received a written question by Miguel Lacruz Montecon. He says, is robot mind reading and ethically acceptable technique on trials and administrative processes? And I think that's a question for Marina.
Okay, thank you, Viviane, and thank you for this question. It's not an easy question, in fact, and I believe there is no one sole answer to this question. Experts say that probably the technology is far from being there. That is to say, a robot able to read the mind. It is probably a possibility in the future, but not really yet. So the answer depends on, in fact, what is mind reading robot. And I think we shall separate two matters. The question of the legally acceptance and the question of the technical relevancy. And in fact, the real question is that of the reliability of the system. That is to say, of course, do we have a technique that is really efficient? Of course, this is probably the main difficulty, and at present it is a technical question. The second question is the question of the legal acceptance of that. And then I think it depends on the tradition of states. And I remember a case. In fact, it's not really a case. It was an article in a newspaper, and it is one of my PhD student, Gail Buroni, who gave me this information. It was about a woman who was prosecuted for murder. And the prosecutor, so it was in the United States, of course, and the prosecutor didn't have much clue. But there was one troubling detail, because the data from the woman's smartwatch didn't match with the information given by this suspected woman. And of course, she is presumed to be innocent. But this fact, that is to say, the data embedded in the smartwatch, this data is part of the body of evidence that could, of course, lead the judge to convict her to murder. So at present, but maybe, I don't know if Karim and Karim want to complete, but I believe every state has its own position on this matter.
Well, thank you, Marina, for this. And we have several questions from the public. One of Manuel Baselga Lopez. It's a long question. I make it short. Very often the citizens do not know anything about AI tools. They are not aware that those exist. Do we need, as states, as countries, as governments, to have rules like GDPR also for the AI tools? Who would like to answer? Karim?
Thank you. Well, yes, of course, I think that we need some regulation. Remember that in the 90s, when internet did emerge, we thought that regulation was not necessary. We even said that the regulation was obsolete because self-regulatory market will make the job. We see now, 25 years later, more or less, that regulation was in fact necessary at that time. So even today, of course, we must tackle those multiple issues surrounding AI and make sure that it is used in the best way possible and not let the market decide for us. That's why the government the government in general, have a very important responsibility to act now and not to wait another 10, 15 years when it will be too late or very difficult indeed to regulate.
Thank you, Karim. And the next question is coming from Colombia, Xavier Francisco Franco. He speaks about the future of law schools. Are they going to become an annex of engineering faculties? And how do we need to integrate AI into the curricula? Gregory, can you answer this question?
Yes, I think that is something that is not yet settled, of course, but we can see that in a lot of countries, the legal curriculum is evolving through different ways. In some kind is to create class of legal informatics. Sometimes it's including some kind of applied mathematics in the courses. Sometimes it's building some kind of interdisciplinary forum in which lawyers have to work with people coming from data science or the faculty of engineering. So I think that everywhere, and I know that there are experience at Marina University that she's leading, and in Karim University also. I think that the curriculum is starting to change and finding exactly this limit that you ask, Javier Francisco, between changing the curriculum and not being lawyers anymore. So the idea, there is a lot of innovation today in the kind of competence that we want to share with students.
Thank you very much, and I would like, time advancing, stop the discussion here, but only for today, because we need a lot more wake-up calls getting out. Thank you, Marina. Thank you, Gregory. Thank you, Karim, for these very important insights. I was fascinated that Marina was quoting McLuhan, who said, we shape our tools and our tools shape us. We better consider that very seriously. And as has been said, also by Karim, the human oversight on design and use of algorithm process is absolutely essential. And in order to be hands-on, I would like to finish with what Gregory said. He said, start now, lean in. It will be mostly because the individual lawyers will not have possibilities to go ahead and to invest into learning of applications of AI. It will be the law schools, very important, but also the bar associations. And it will need to be a wake-up for lawyers in big institutions or in small cabinets, just to know that, and that for me was very important learning, that law firms, big or small, will be challenged. And if they do not know about AI, if they do not understand the system, they cannot survive in the long term. And that should be the lessons to take with us also to Colombia and to our Congress, because we have also to see that the rule of law stays in the hand of lawyers and not only in the hand of those who have the capacity, the possibility, the money to build this capacity, but to all lawyers, because that is part of the rule of law, that there is equality and that there is choice from the citizens. So thank you, all of you. Thank you for the World Association to have made this possible. It is our first public discussion about AI, and certainly it is only the beginning. Thank you for all of you, and have a nice day or a nice evening.
Thank you.
Many thanks. Bye-bye.
Bye.